Welcome to this episode of Post Grant Radio, brought to you by Fish & Richardson. This podcast is dedicated to discussing the latest news and developments in post-grant proceedings before the Patent Trial and Appeal Board. Host Rick Bisenius, an attorney at the Twin Cities office, talks with practitioners and thought leaders across the country discussing a wide range of post-grant topics.
Hello, this is Rick Bisenius, and I'm a principal out of Fish & Richardson's Minneapolis office, and with me here today is Tom Rozylowicz, a principal out of our DC office. I'm excited to have you here with me on my first episode taking over the hosting duties of the podcast.
Thank you for having me. It's a pleasure to be here, and I look forward to talking about the confluence of AI, machine learning, and post-grant disputes.
It's a shame we can't be in the same room together. It's been a couple of years since we've seen each other in person, but I'm glad to at least be hanging out with you virtually over Zoom.
Absolutely.
So before we jump into things, can you tell our listeners a little bit about your practice?
Yeah, thank you, Rick. So my practice is about half traditional patent prosecution, filing new patent applications, getting cases allowed that are underway, and the diligence associated with managing patent portfolios. The other half of my practice is post-grant disputes, primarily on the petitioner side, although I've done a good bit of patent owner side over the years as well. I'm also privileged to serve on the board of directors for the PTAB Bar Association, where we just had our second annual conference of 2020. We're trying to reset to a schedule that was altered because of the pandemic. We'll be going back to a March annual conference, and so we will have been in the process of having our three annual conferences in about a year and a half.
And you are actually in charge of organizing the PTAB Bar Association conference this year, correct?
I'm a board liaison to the annual conference committee. So I've been a committee chairman in years past, and upon elevation to the board, I became the board liaison to the annual conference committee to support the chairman.
Oh, okay. I'm sure it was a lot of work. So before we get into our topic for today, I was hoping you could just tell me about something you did this year, something fun you did this year, not post-pandemic, but after the darkest days of the pandemic that you weren't able to do in 2020.
Yeah, thank you. I think it's a great question. You mentioned the opportunity to sit down and work together in person. I can tell you something we did in 2021 that we didn't do in 2020 is we were able to travel overseas. My wife and I just got back from a week in Greece, and we weren't sure what we were going to get from a pandemic and restriction perspective, but I got to tell you, it was surprisingly normal. We just had pictures of our vaccines card handy, and we're able to enjoy a lovely week in Greece. So I think things are getting back to normal.
That's great. Where in Greece did you go?
Athens, Santorini, and Crete. And just a spectacular time. Caught the very end of the shoulder season, and honestly, I can't wait to go back with family and the kids. Yeah,
I went for my honeymoon with my wife in 2009, and we hit up Athens and Santorini and Mykonos. And but I just remember the sunsets on Santorini were amazing. Were you able to catch one while you were there?
We were able to catch a few nice sunsets. Just getting out there, and frankly, it was the best thing of the island was taking in the sunsets.
Yeah, I haven't been able to do a long vacation with my family yet, since the pandemic, but we're looking forward to hopefully doing something soon. But it's great to hear. I'm glad you're getting out there.
Absolutely.
So you're joining us here today to talk about some recent post-grant decisions that touch on artificial intelligence and machine learning. Mm-hmm. So before we get into how that touches on post-grant proceedings, can you tell us just a little bit about artificial intelligence and machine learning and maybe the difference between the two?
So just shooting from the hip, I think that artificial intelligence really focuses on those aspects of software that maybe are making decisions or arriving at conclusions that no human administrator or person involved in the process has yet made. Whereas I think machine learning focuses on a very complementary skill set, and that's really how do computers reconfigure themselves to better support different computational objectives, right? How do you change your algorithm? How do you change your model? How do you react to the stimuli that you're receiving in order to better make that prediction and determination in the future?
That's great. Could you give us some examples of artificial intelligence or machine learning that some of our listeners may have encountered in their everyday lives?
Sure. I think it's become very much a consumer-facing technology in the past couple of years. I think prominent examples of different AI machine learning technologies include IBM's Watson. There's a number of prominent virtual assistants, including the Amazon Echo and Apple's Hey Siri tool. And I think we're also seeing this typically in social media with different instances of facial recognition and object recognition technologies. So, for example, when you post a picture of your vacation, I think there's a lot of preliminary processing that tries to identify who's in that image with you.
Oh, that's really interesting. I guess I hadn't really thought too much about what was going on behind the scenes in those sorts of technologies, but that makes sense.
And of course, having mentioned one or two of those names in the background, the automated assistant thought I was asking a question there. So they really are pervasive in the 2021.
Wasn't there a Super Bowl commercial a couple of years ago where it used one of the trigger keywords in the commercial and people had their devices going off at their homes all over America?
I think that's right. I'm surprised it hasn't happened on more occasions, but I guess it becomes sophisticated enough to avoid some of those real-time challenges.
So one other thing I was wondering, and you might not know the answer to this, but are you aware of what sort of developments in the actual technology areas have led to the recent expansion of artificial intelligence and machine learning in these sort of user technologies?
Yeah, so I think that's a great question. Certainly, if you look at the patent literature itself, as well as maybe some of the more formal academic literature, things like ACM journals, people have talked about artificial intelligence and machine learning for a long period of time. I think certainly going back decades, but at least going back to my time, there were a lot of advanced discussions on optimization in the 1990s, how AI could be used to achieve those optimizations. But from my perspective, they really didn't become commercially feasible on a broad basis until maybe the 2012 timeframe. And I think there's a few reasons for that. First, I think the adoption of wireless phone technologies and how that drove the economics beyond that of even Moore's Law and what we were seeing with desktop and laptop computers, right? The ability to build data centers that were basically using non-volatile RAM that was going in all of our wireless phones, the ability to bring those technologies into the data centers so that you could perform massive amounts of read operations without having to access a relatively slow hard disk drive certainly created access to far larger data sets. And so that's really, from a hardware standpoint, I think was one of the key enabling technologies. And I think the other key enabling technology was the release of a number of commercial off-the-shelf tool sets, things like AWS, Azure, and TensorFlow have really had a revolutionary impact on how wide an audience can adopt AI and machine learning technologies. And I say that because while we saw instances of AI and machine learning technologies being commercially adopted in 2012, what we've really seen that comes about as a result of these development tools is small organizations that have access to their own large data sets can integrate these technologies into their operations. They don't even need to set up a data center in many cases. They can simply go to the cloud and they can use Azure, they can use AWS to harvest and process their data. And so what I've seen in my own practices, even from in some cases some very small companies and small startups, is they've been able to realize and incorporate these technologies into their solutions in ways that previously probably would have required a far larger development staff, a far higher end development staff in terms of people's ability to access and work with experienced programmers that are comfortable developing in AI and machine learning technologies.
Oh, wow. That's really interesting.
And, often, a couple ways to look at the size of the AI and machine learning market, by number of patent applications, but just in terms of looking at different, the size of the tools market is, I think according to Global Newswire, the AI and machine learning market was estimated to be valued at $8 billion in 2016. My numbers show that in 2021, it'll be $30 billion. I think that's on the low side. But whatever that benchmark is, I think the forecast I saw is that AI machine learning markets will be valued at $300 billion by 2026.
Oh, wow. So it seems like it's going to be an important area, for the business side of technology where people are going to want to be heading. So today you're here to tell us about some recent research you did with respect to artificial intelligence and machine learning in post-grant proceedings. Can you tell us a bit about that?
Yeah, so sometime back I was asked to size up what's taking place with the AI and machine learning technologies being considered for post-grant disputes. And I thought I was going to have the problem that you often encounter in trying to identify trends and kind of overall effectiveness rates in post-grant disputes, and that is the problem of having too much data, right? It's often difficult to process these technologies and develop conclusions and trends. And what I encountered in this case was there simply weren't that many AI and machine learning cases, and we expanded our definitions, we expanded our filters to try and find more cases that we felt were representative of AI machine learning technologies. And we did find some useful data points, but in peeling back the onion, I think we can identify some reasons as to why what I think we're on the brink of likely to see a lot more AI machine learning cases going forward, even coming from a context where there haven't been that many AI machine learning disputes to date.
Is that really just a function of more machine learning and AI patent applications being filed in the last decade or so?
Well, I think that's been a big part of it. Certainly, if you could take a look at where people are filing applications, I think you'll readily see that those art units processing AI and machine learning cases are busier than ever. I think some of the numbers I saw that the number of AI machine learning cases have doubled in the past decade and a half. And again, that metric seems like it's even on the low side. But I think you also need to consider that, again, so people when they were previously filing these applications, at least the earlier cases, weren't doing so with the benefit of these commercial off-the-shelf tools we previously mentioned. But I think you also have to consider that in the context of people being reluctant to engage in disputes related to software as a result of Alice, the Supreme Court's Alice decision, right? So we know in 2012, the America Invents Act became effective on September 16th after being signed into law 1 year previously. Then in June of 2014, the Supreme Court decided the Alice decision. And along with that, they actually had a very effective covered business method post-grant vehicle to consider certain classes of essentially software innovation. And so together, what do we have? We have a very effective dispute resolution mechanism before the PTAB because of the America Invents Act. And at the same time, we're all trying to process what does Alice mean? What are the bounds of software innovation going forward? And so I think really from 2014 through maybe we saw some of the cases that shed some useful guidance as to what class of cases were software eligible in the 2017, 2018 timeframe. I think that resulted in a huge pause and reluctance to move forward with disputes related to AI and machine learning cases. Now, I think what we've seen as a result of people getting more comfortable with that jurisprudence, I think there's, again, I don't necessarily know that it impacted all that many software cases that were being filed, software patent applications that were being filed, but I certainly think it gave pause for people's, again, willingness to bring those disputes going forward. How is the district court going to look at this case? How is the PTAB going to look at this case going forward?
So it's more caution on the side of patent owners with respect to just seeing how these sorts of trials involving this sort of technology is going to play out.
I think that's absolutely right.
So in conducting your research, you identified a number of cases in which AI and machine learning were involved in post-grant disputes, and you've identified a few specific cases to talk about today. You want to tell us about a few of those?
Sure. So I think two of the cases that maybe first paused some of the concern over after Alice were the EnFish case, where the Federal Circuit upheld the patent claims directed to a logical model for computer databases. I think there was all sorts of innovation taking place related to those class of technologies where people could look at the claims at issue in that case and take comfort that at least they were similar enough to the patent owner in that case where they felt they had a basis to move forward in those circumstances. Another case that I think was also largely important was the Amdocs case versus OpenEd, and again at the end of 2016, I think again that was just reinforced. Reinforced a lot of the optimism that came about as a result of the Enfish case. And we've seen other cases since then. The McRow class of cases, and McRow and its progeny certainly helped a lot, and also give comfort to people pursuing software-related innovation. And again, none of these cases are AI or machine learning cases per se, but under the broad rubric in which AI machine learning cases fall as a software-related case. Granted, my perspective is they're often far more complex. At least if the bounds were that broad under Enfish and its progeny, if they felt more comfortable moving forward with far more focused AI and machine learning cases.
So those are some Federal Circuit cases dealing with the subject matter eligibility difficulties involved in AI and machine learning patent applications. Can you tell us a little bit about some of the post-grant cases, some of the IPR cases that you've identified, and the challenges faced with respect to challenging patent validity based on prior art publications?
Right. So when I started this effort, I thought we were going to struggle with, the question is, what were your predictions at the onset, and then how did the data actually bear out? So I think one of the things we thought we'd see in the onset where we would see dispute over expert qualifications, who was really a posita when it comes to AI machine learning cases, especially when the skill set and applicable time frame may not have been that common of a skill set. The other thing I thought we were going to spend a lot of time looking at prior art that came from academic literature, the ACM journals, IEEE journals, and oftentimes that class of literature isn't as well structured as what we often find in patent literature. And so I thought we were going to deal with a lot of confusion over how petitioners were looking at non-patent literature and trying to ascertain structure for what oftentimes is fairly flexible architecture as described in academic literature. And then there's a number of cases out there that I'll just really speak to at a very high level. For example, one of the cases is Cisco Systems Centripetal Network. It's been a number of other cases, and dealing with Comcast Cable v. Worldly Guides was one of the other cases, as well as a few other cases. We found it was a fairly split record on disputes across the board. I think what we found in these cases is that there was a surprising amount of patent literature that was considered. I think was one of the things we learned when we look at these cases. I think in surveying the cases, we identified about half the cases relied on patent literature, which to me was a very surprising database, or a surprising data point. One other thing that also jumped out at us is people are oftentimes continuing to use the techniques they used to successfully prosecute software applications in the past. And so if there's language that deals with AI and machine learning specific concepts, it often is typically limited to one element. If there's 4 elements in the claim, only one element might in fact focus on those aspects that are dealing with AI and machine learning innovation. And so you can imagine that if the other 75% of the claim language is in fact dealing with conventional software technologies, you can probably rely on conventional software applications to meet and address those limitations.
Were you finding that a lot of times the petitions would contain 103 combinations using some patent literature and some non-patent literature due to that sort of split in claim elements having AI focus and others not?
It did. We saw that on more than a few occasions, and I think that was a safe place to be. I think one of the things we often hear when considering a post-grant case is, why are we, given the flexibility of obviousness under KSR jurisprudence, do you really need to stretch, before a technical audience at the PTAB, do you really need to stretch the art to maybe go to a difficult position when you have far more flexibility? It's a far more efficient inquiry just to rely on two references in combination, provided that you can establish the motivation to combine. And so I think when I looked at these cases, the bar appeared to be far more comfortable taking that approach of drawing upon the best art for each of the limitations and then taking advantage of the flexibility that obviousness provides.
That's great. So looking at the notes that you sent me on some of these cases, it seemed like claim construction under 112F, which, just to pause for a second for our listeners that can't just rattle off these numbers off the top of their head, 35 USC 112F relates to claim construction for means plus function claims, which is a claim element that'll recite a function, but not necessarily the structure that performs it. And so those types of claims elements require specific instructions. But I was wondering if you could talk a little bit about how that has touched on these AI and machine learning post-grant cases.
Right. Certainly as somebody who's done a lot of petitions, how we grapple with 112F, how we grapple with the means plus or step for doing something is an area we spend a lot of time, just because I'd say that the spectrum of how it's considered can vary tremendously. So it's something where we gives us great pause. We in fact move forward. And yet for the handful of cases that directly align with 112.6 cases, it really wasn't an issue at all. Petitioners appeared to meet the burden and provided inquiry in those elements and provided analysis for those elements that really warranted the 112F consideration, and for the other elements, it simply wasn't an issue. So I guess one of the surprising data points is that 112F hasn't been a larger issue in consideration of these cases. Maybe just because the bar is just so wary and as a consequence thorough in trying to address those points.
Thanks. So stepping back a little bit, I was wondering if you could maybe touch on some of the challenges that patent owners may face when trying to assert AI and machine learning patents.
So a couple of things jumped out at me. One thing, it really kind of bore on the trends that we saw come out of this, is that there really weren't a whole lot of claim construction disputes, right? I think there were, at least in some cases, there might be some reference to a term that had a spectrum of definitions. I think one of the key terms that appeared in one of the cases related to a self-organizing map. And I think the board grappled with that, terms like that in a number of cases as to whether they go with a broader definition or a narrow definition. And I think what we saw in a few cases is that the patent owner just didn't have the detail to be able to either amend their claims or focus on dependent claims. They just didn't have that detail to move to a more secure backup position for whatever reason, or frankly, the patent owners chose not to amend in those cases as well. And so that was, for me, was one of the things that jumped out. I thought we'd see a lot more discussion over the meaning of some really complex terms, and certainly I saw the potential that was there in these cases, but it really didn't appear to be that prominent of an issue in looking through the final written decisions. And so my takeaway for patent owners would be, especially for somebody who's in the application stage of things, do you really have the detail on which to hang your hat when grappling with something that has a variety of different definitions? And, especially in drafting cases, I often will work with a colleague who's drafting the cases and have the conversation. So when push comes to shove and we're engaged in this claims construction issue on this particular point, show me your backup detail to ensure that we can prevail first in examination, and then later on in any form of dispute, to be able to speak to any concerns that, if there's a gray area in the first instance, when forced to respond to it, do we in fact have the winning record to move forward with it?
So it sounds like one key to having a strong artificial intelligence related patent application is just details on how it's implemented.
I think that's right. I think in far too many cases, people go about the disclosure trying to spend equal time on every aspect that appears in the figures, when in fact I think you want to spend 30% or more on, if it's a true AI machine learning case, can you spend 35 or 30 or 40% of your effort on those aspects that you think it's the area in which your case will rise or fall going forward?
Thanks. It sounds like a really helpful suggestion for patent prosecutors out there that are, delving into an area that still is pretty new.
A couple other observations I just might share with you, if I may.
Yeah, go ahead.
So one thing I think we've seen to date is that many of the disputes, in fact, were involved with consumer-facing products, right? There was some operator, some administrator that was directly, I'd say, interfacing with AI machine learning technology on a, if not directly, it's not too far below the surface. And I think that really speaks to the fact that proving infringement for cloud-based functionality often can remain a challenge. Certainly, we've seen all sorts of detail that comes out in different form as to, call it what you will, marketing literature or other aspects that speak to the AI and machine learning technology that's taken place in the cloud. But there have been a lot less of those disputes. And even in those cases where arguably there is some AI or machine learning taking place in the cloud, oftentimes it's a subject of product literature or something where there's an administrator that's directly hands-on with that technology. So, for example, firewall technologies, right? While your average consumer may not, in fact, be interfacing with their own firewall, odds are there is some firewall administrator, some security administrator that is managing and manipulating those technologies to respond to some dynamic threats on the internet. In those cases, those are far more likely to be asserted than perhaps some analytical engine that's taking place in the cloud where most of the audience is just oblivious to what's taking place and how those derivations are being made.
So in other words, you might be a patent owner with this great patent that protects your artificial intelligence technology, and there might be a competitor out there infringing on your patent, but it could be very difficult to tell they're infringing on your patent in these non-client facing situations.
Absolutely. I think that's exactly right.
Are there any other observations you wanted to share?
Yeah, so a couple of the things. Again, we've already talked about the fact that I think this really speaks to best practices, that even where AI and machine learning technologies are the crux of the invention and not, perhaps some back position or some tangential aspect, people are claiming maybe one element that draws upon the AI and machine learning components. They're not trying to bring that complexity to all the elements. And I think that first results in more efficient prosecution. It probably does make for maybe a more focused patent to address in a petition for IPR later on. But again, I think that's among other things that's really where you have dependent claims that can really breathe a lot of detail into some broader terms if you happen to use those earlier in the case. Finally, the other surprising thing for me is I think oftentimes AI machine learning technologies are justifiably called, among the more complex technologies being considered at the patent office. I thought we would see lower success rates for petitioners, but at least in those few early cases we've seen at the PTAB, petitioners were generally successful across the board. There's very few data points to suggest that petitioners won't be as successful addressing AI and machine learning cases as they would be in other cases, for example. And that to me was a surprising data point, just because I know, frankly, how much more difficult AI and machine learning literature and prior art, be it non-patent literature or patentable literature, can be.
That is interesting. And I'm sure you don't have this data point, but I'd be interested to see how that compares to validity challenges in the district court. Sort of the difference between these PTAB judges who usually have the technology background, or at least, one or two of the judges on the panel will, versus a true layman jury that wouldn't necessarily have this electrical engineering or computer science type background.
Mm-hmm. I think that's right.
Well, I've taken up a lot of your time this morning, Tom. I appreciate that. But before I let you go, in taking over the hosting duties here, I'm instituting a new segment that I call the lightning round. So I'm going to hit you with some lightning round questions, if that's okay with you. And it's okay. You can pass on any of these. This is just kind of for fun at the end here.
Yeah, fire away.
All right. So I'm going to start you off with an easy one. What year was the first IPR petition filed?
2012.
Correct. Bonus points if you can give me the date.
September 30th, 2012.
That's close. That's really close. It was September 16th. Somebody was ready to file a petition on the day that the America Invents Act went into effect on September 12th, or September 16th, 2012. But anyway, that's 1 point. You got that one. Okay. Question 2. So I learned yesterday that your daughter has started a PhD program at Stanford, correct?
That's correct.
All right. What year was the infamous Cal-Stanford football game in which Marriott Ford had to dodge members of the Stanford band to reach the end zone for the game-winning touchdown?
Total guess, I would say 1985.
That's really close. It was 1982.
All right.
I can't give you the points though. We're very strict here.
Understood.
All right, question 3. What's the maximum number of claims a petitioner can challenge in an IPR petition?
I don't think there's a limit.
That's correct. That's a trick question. You got it. All right, question 4. A few years ago, Fish and Richardson moved the DC office to the new wharf development along the Potomac River. The question is, what's your favorite stall at the municipal fish market?
When it's in season, I'm always a fan of the soft shell crabs. So you ask what's my favorite stand. Whoever has the soft shell crabs is where I'll go in season, typically July.
I know which one you're talking about that has the sign out for the soft shell crabs, and I also can't remember the name of the actual stall, but yes.
Captain White's maybe.
All right, question 5. Halloween's coming up.
Mm-hmm.
What's your favorite horror movie?
I get scared pretty easily, so
yeah, my wife's the same way. I've kind of stopped watching horror movies ever since we've been dating because it gets so easily scared that I have to find the few opportunities to like watch them with other people when she's not around.
Sure.
You can pass.
Great question. Friday the 13th, I guess. Yeah.
Yeah. All right. Last question. So we talked about 112F construction before. So this is a 112F question. A claim element reads, quote, a means for winning Tom Rozylowicz's heart. What is the corresponding structure?
A Cubs World Series championship trophy from 2016. How's that?
That's a great answer. I happened to be I didn't go to the game, but I'm not a Cubs fan, but I happened to be in Chicago during Game 6, actually in Wrigleyville, visiting some friends during Game 6, and it was amazing to be around just that energy in the city. Everybody had been waiting for, had it been 114 years at that point?
I think so.
All right. Well, thank you so much for joining us today, Tom. I think we're going to wrap it up there. I'm Rick Bisenius. So thank you all for joining us on this episode of the Fish Post-Grant Radio podcast.
We want to remind our listeners that the content of this podcast is for educational purposes only and does not necessarily reflect the opinions of Fish and Richardson nor any third party involved and is not intended to address every court or case situation. Be sure to visit fr.com to listen to all of our past episodes and subscribe to this podcast. You can also follow us on social at Fish Richardson.